When I find myself in times of trouble, Mother Mary comes to me.
Jude, don't make it bad. Take a sad song and make it better.
You might have heard the news that has all of Hollywood losing their sanity. Movie watchers can now apparently sue companies that release misleading movie trailers, according to a recent federal court order. A lot of industry insiders seem to be panicking, thinking this may be the end of movie trailers as we know it.
You're here to hear about this crazy story. This story's nuts. Really nuts. So listen to this. Movie studios can now be sued under false advertising laws if they release deceptive movie trailers.
After all, most movie trailers are misleading in some fashion, as otherwise they would be giving away a given movie's plot. But is this news story being a bit overblown? What does the federal court ruling actually say? Well, let's get into it. So let's start with the background of this case. Sometime in 2021, the plaintiffs, Peter Michael Rosa of San Diego and Conor Woulfe of Maryland, each individually were browsing their Amazon Prime video catalogs, looking for something interesting to rent. As is often the case, and as many people tend to do, I know I tend to do so, they didn't really know what they were looking for. So they just started watching various trailers on the rental service until they found something that caught their interests. At some point, the two plaintiffs each individually stumbled upon Universal's film, Yesterday. Now, Yesterday is a film about a failed musician who hits his head during a blackout only to wake up to discover that the world's knowledge of the Beatles has been erased. And so he takes advantage of this opportunity and adopts the Beatles songs as his own and quickly becomes world famous. But the thing that really caught both of these plaintiffs' attention was one particular moment in the trailer that they were watching for this movie.
We would like you to write something right now.
Something in the way she moves.
No one's ever written this many great songs. How do you do it?
Attracts me like no other lover.
Allegedly, based on this moment in the trailer, both plaintiffs decided to rent this movie as they were big fans of Ana De Armas, who was pretty much rising to stardom pretty quickly at that time. They wanted to see what that potential love interest story might be, and so they decided to rent the movie for $3.99. The problem was, Ana De Armas wasn't in the movie at all. Her character and her scenes were entirely cut from the film that was released for streaming, but the trailer still kept those scenes in to entice viewers to rent the movie. So in response, each plaintiff filed a class action lawsuit against Universal Pictures, alleging violation of unfair competition law, violation of California false advertising law, unjust enrichment, breach of implied warranty, and a whole slew of other things related to consumer protection and the Uniform Commercial Code. Universal immediately filed what's called an anti-SLAPP motion to dismiss the lawsuits. Now, an anti-SLAPP motion is in short a motion to combat strategic lawsuits against public participation. In other words, it's a quick way for defendants to get a case dismissed that is filed in order to stifle their free speech rights. For example, if someone's saying something you don't like and you decide to sue them just to get them to stop talking, to scare them, to chill them from speech, well, that's when an anti-SLAPP motion would be filed to immediately get that case resolved so that your speech isn't restricted for any longer than necessary.
Why are you slapping a monkey?
Teddy, this guy's been pushing me and I'm sick of it.
The parties each filed legal briefs arguing whether the case should or should not proceed under the SLAPP statute, and on December 20th, 2022, the court issued a ruling on the matter, in part answering the question of whether individuals can sue companies for releasing misleading movie trailers. With that said, let's have a little overview of what both sides here were sort of trying to argue. So I'm going to start with the defendants because I think the plaintiff's main argument is that they were misled. But the defendants had threw out a whole list of different defenses for why this claim should not proceed. Their first defense was, that this is a expressive work. A trailer is an artistic expressive work that tells a 3-minute story conveying the theme of the movie, and should thus be considered non-commercial speech. If the trailer is non-commercial speech and is in fact an expressive work, it would have some protection under the First Amendment. It's very difficult in the law to ever outweigh someone's First Amendment rights. There has to be a really substantial showing that there's some kind of harm that's going to happen. In this case, if this trailer was not considered to be commercial speech, it's very difficult to see how a court would ever decide that the defendants did anything wrong by exercising their free speech rights.
Today, we celebrate our...
However, the plaintiffs counter-argue that no, this trailer is commercial speech. The primary purpose is to sell a product, the finished film that's eventually released on streaming or in theaters. And the trailer is designed to get as many people in the theater as possible, not to be expressive. In other words, a trailer accomplishes its job if it sells tickets, not if it's really pretty and a work of art standing on its own. So next, the defendants also argued that everyone does this. Everyone releases trailers that eventually aren't like the final cut of a film. Movie trailers have for a very long time included clips that do not appear in finished films. The defendants specifically cited Jurassic Park as an example. I would have cited things like Rogue One, The Avengers, Spider-Man. So as an example, Rogue One had a lot of reshoots. So the initial trailer is almost entirely different than what we saw in the final finished film. However, there is a distinction. The main cast is the same. The plaintiff's counter-argument is, yeah, trailers might mislead, but they never mislead as to principal cast that's featured in the film. It's rare that you would see for example, a trailer for Indiana Jones starring Harrison Ford, and then find out in the movie that Harrison Ford isn't in the movie at all. That would seem like an easy claim for a lawsuit.
Get back!
The defendants next argue that this will somehow open the floodgates, where everyone is going to just start suing every movie company, because classifying trailers as commercial speech could open the door to a parade of lawsuits from filmgoers. Now, the plaintiffs and the court's counter-argument is, this would only apply if a trailer misleads. In essence, the plaintiffs are arguing that this is a narrow interpretation and narrow argument because it only applies if a reasonable audience member, under the same circumstances, would be misled. The defendants next argue that the claims are somewhat subjective, that the audience can make claims based on entirely subjective expectations. For example, well, I thought this character was going to have more lines because they took up 50% of the trailer, but they only took up 20% of the movie. But the plaintiff's counter-argument is that these are objective claims. The fact Ana De Armas was not in the film, it's simply a fact that she was not in the film, but she was in the trailer. Subjective audience opinions are not being considered in this case, and there is no precedent being set by this case regarding subjective opinions. And finally, the defendants argued there was no misrepresentation. They never said Ana De Armas was in the film. They never said explicitly starring Ana De Armas. She wasn't included in some kind of credit in the trailer. She was just in a brief segment. The plaintiff's argument is that doesn't matter. She wasn't a background actress. She was the most prominent star in the trailer. She was center frame in her part of the trailer. She was in a key story point within the trailer, if you consider the trailer itself telling its own complete story. And trailers typically include actors that will actually appear in the film. So let's take a look at what the judge actually ruled in this federal court order. So as you can see, the case is Conor Woulfe et al. Versus Universal City Studios LLC. The judge is Stephen V. Wilson, a U.S. District Judge. And this order is an order granting in part and denying in part defendant's special motion to strike. And that special motion to strike is of course that slap motion that I mentioned. So first in this order we get the introduction that basically goes over the facts that I already covered. You have the plaintiffs who watched the trailer, they were misled, and they sued Universal along with a whole class of different people that might have been damaged by these misleading trailers. Something interesting in this order is there's an emphasis on what Ana De Armas' qualifications are. A less known actress might make for a weaker case, so the more popular an actor is in the trailer, the stronger a case would be if they don't appear in the final film. So here you see that the order mentions that Ana De Armas is a famous actress who has appeared in multiple films. She was a 2020 Golden Globe nominee for Best Actress in a Comedy or Musical, and she has approximately 6.8 million followers on Instagram.
You're late. Vamos. This is the biggest job I've ever had.
Ana De Armas and Daniel Craig.
So I want to kind of skip ahead here and just go to Universal's first argument. Universal's first argument is that there was no misrepresentation, as I mentioned. They never said that Ana De Armas would be in the movie, and the whole claim that there was a misrepresentation is simply too vague and non-specific to definitely represent to viewers that she was going to be in the movie. The court disagrees with this argument and essentially says even an implied assertion may be sufficient. So even if you imply someone might be in the film, it's enough to sustain a possible claim if they're also able to show damages and other things of that nature. Universal tried to cite a whole number of different cases to kind of bolster their claims, but the cases they cited weren't actually on point. The cases they cited had to do with something called puffery, which is essentially exaggerations, things that make yourself look better that you often find in advertisements. This is the best movie in America, or critics are loving this film.
Critics are calling it sensational. Earth as we know it will never be the same.
They're not entirely provable statements. Those seem like examples of puffery, and those would arguably be okay, whatever this case result might be. So the court makes the contrast to the present case, saying this alleged misrepresentation in this case is a lot more concrete. The plaintiffs, the defendants rather, Universal, made a factual representation that is seen and an actress that showed up in the advertisement of the movie would appear, and she didn't. Universal's second argument is that whole thing about Ana De Armas only appearing for 15 seconds. She didn't have any dialogue in there, her scenes in the trailer, and the film never explicitly, or the trailer never explicitly stated that she was going to appear in the actual movie. The court throws this out pretty quickly because the plaintiffs allege movie trailers are understood by movie viewers and consumers to convey what actors will appear in the advertised film. De Armas is a famous actress. She's appeared in other movies. It's very plausible to think that she was in the trailer because you would think she would be in the movie as well. Not only that, but the way she's portrayed in the trailer makes it seem like she's going to be a love interest. She seems to make the main female character in the film upset, and she conveys a key part of the overall story in the trailer. In fact, when you're watching the trailer, there's almost like a beat, there's a pause. She's almost the heart of the trailer itself.
The one, the only, Jack Mallet! We would like you to write something right now.
Something in the way she moves.
No one's ever written this many great songs. How do you do it?
Attracts me like no other lover.
So Universal's final argument is that the plaintiff's theory, or their claims, they lack a principled limit. Where does this end? What can you not bring a claim for as far as what's in the trailer? What can you not sue over? Universal posits a host of what-if scenarios, contending that if a court were to permit plaintiff's theory, then plaintiffs could assert that they were led to believe that De Armas would appear for a certain amount of time, occupy a specific role, or receive a speaking role. Would this be false advertising as well if a person has a speaking line in a trailer but they don't have a speaking line in the actual film? Now the court pushed back on this argument, saying no, this is all covered by the reasonable consumer test. In order for the plaintiffs to win, to sustain their claim, they have to show a probability that a significant portion of the general consuming public or of targeted consumers acting reasonably under the circumstances could be misled. And the court's holding is limited to her representations as to whether an actress or scene is in the movie and nothing else. What would an objective person under these circumstances feel? Would they be misled? So that should give some peace of mind to movie companies, because you would really have to mislead a significant portion of your viewers in order to sustain this kind of claim. So the final conclusion of this case is that certain claims were dismissed under this anti-SLAPP motion. However, a lot of their state law claims, unjust enrichment claims, are allowed to proceed so that the plaintiffs still have a case, and the case will now proceed predictably to discovery and eventually some fact-finding, a possible trial, to settle this matter, although it's possible that the parties will settle out of court. But essentially what a lot of people are freaking out about is that this will somehow hinder movie companies from ever releasing trailers, because they're going to fear that their trailers are somehow misleading. However, this is a very limited case where you had an actor that was put in the trailer despite the movie knowing that they're not going to be in the actual film. By the time the film was on streaming, the film company knew perfectly well that Ana De Armas was not going to be in the movie that you're about to rent, but they still kept her in the trailer. So as long as films don't do that deception, which, as the plaintiffs argued, is very rare and doesn't actually happen that often, I think most movie companies and trailers are going to be just fine. Until next time, this is Reels and Gavels.